It's our view on behalf of the plaintiffs that these proof of claim forms are not discoverable for a number of reasons. First of all, the supremacy clause of the Constitution. These TDPs, trust distribution plans, are orders of a federal court. And some of them, most of them have very express confidentiality provisions. I've had one of them up here. If you can get, Tim, you had my blow up there before. Right. This is the Owens Corning trust distribution plan, and it makes clear specifically in it that the claimant's submissions or proofs of claim are confidential. A proof of claim form and materials related thereto shall be treated as made in the course of settlement discussions between the holder and the PI trust, and is intended by the parties to be confidential and to be protected by all applicable state and federal privileges, including but not limited to those directly applicable to settlement discussions. Can I get the next slide? Specifically, they also say sole benefit, that the evidence submitted to establish the proof of Owens Corning fibroid exposure is for the sole benefit of the PI trust, not third parties or defendants in the tort system. That is a very specific and express confidentiality provision as an order of a federal court that is a federal regulatory, a federal plan here. Could I have the next one as another example? National Gypsum's trust distribution plan, the court ordered, submissions with respect to asbestos claims asserted in the NGC Bodily Injury Trust shall be deemed to be part of a settlement discussion and be kept confidential and shall not be admissible or discoverable in any court proceeding not directly related to claims submitted under these claims resolution procedures. So with those very specific provisions in a federal order, an order by a state court to turn over these materials would be in direct contravention of an order of a federal court, and there's why you have a supremacy clause issue. One of the things that we've seen in New York, at least, is that there has been a request for just blanket orders to turn over every proof of claim against every trust in every case. And this presents other problems as well. First of all, not only do you need to look at the express provisions of each individual trust to see whether or not the disclosure would violate that particular trust's confidentiality provisions, but this is work product. This is information that our office, for example, and other plaintiff firms, we go to the same depositions the defendants do, and we hear about the same work sites and the same co-workers, and we evaluate that and chase these people down and send investigators and try to locate them and determine whether or not there are, which products of bankrupt entities are at which particular sites. In addition, this is material that's prepared in anticipation of litigation. The courts have held that a bankruptcy claim is litigation. So as a result of that, when a material is prepared in anticipation of litigation, the defendants have to prove substantial need and undue hardship, and that they are unable to get this material by any other means, which they are, in our view, completely capable of independently determining which bankrupt products are at which sites. So, in New York, for example, the burden of proving up shares of relative culpability of other joint tortfeasors is the defendant's burden. That's what they have to do. And so an order, even if it weren't in direct contravention of a federal bankruptcy court order, to turn over these POCs would somehow make it our burden to turn over our work product and our materials prepared in anticipation of litigation in order to make us lay off shares of the defendant's liability, and that would be, we believe, completely inappropriate.